Thank you, Mr Chairman. Mr Chairman, I just want to deal with the points that have been made by the previous speaker and by the Minister and the Chair. Firstly, dealing with the points that Simon Bridges has made, and I listened carefully to his speech. He's been a trial lawyer. He's one of the few people in the House who can speak on this issue on the basis of some practical experience. But here's the problem with the provision that he's explained and that the Minister referred to earlier. It provides a discretion to a judicial officer to say to somebody who is accused of a crime, don't show up to your trial, we're going to do without you, and you can appear on the screen. And what it does is it then goes on to fail to confine that discretion in any meaningful way. It simply leaves it up to the judicial officer, who for the moment, under the provisions that we're dealing with, is a qualified judge, a tenured judge. But who knows what this Parliament might do if it goes through this door? Who knows what further weakening might occur to the protections? We might end up with community magistrates, justices of the peace, or other part-time or temporary judicial officers exercising this power. And if we do that, if we allow that power to go forward in this bill without defining very carefully the sort of circumstances in which a judge might justifiably try a person in their absence, potentially sentence a person to imprisonment in their absence, then I think we're making a major mistake, sir. We are making a major mistake by trifling with people's civil liberties. It's true, as Simon Bridges said, that in some cases the common law finds practical ways to ensure that the proceedings of a court are respected and not disrupted. If there's a disturbed defendant, he or she can be removed from the court. But you never know until you actually got the person there in front of the presiding officer how they're going to behave. It would be a gross violation of that person's civil liberties just to say, because they misconducted themselves once, we're just going to deny them the right to appear in a court ever again because we think it's likely that they might behave in that fashion once more, and we don't want to have that in our court. We don't want to have that sort of behaviour, so we're going to just try them by video. That is the door that is being opened by the drafting of this legislation. And the Minister and the Chair is looking at me and shaking his head. But he knows as well as I do that unless the discretion that is provided by the legislation is better fettered, unless we go through the bill and say these are the precise circumstances in which Parliament would be willing to countenance trial in absentia, effectively, trial by video, then we are opening the door in that way. And so my submission is it's a very unwise thing to do. It isn't a sufficient safeguard just to say it's a judicial discretion, so it's okay. Scholars of legal history know that some of our judicial officers in the past have misconducted themselves. There is such a thing as judicial tyranny if you don't define judicial discretion. That's why we have the Bill of Rights 1688. That's why there was a reaction to cases like the prerogative in Saltpetre and the ship money case. Those were judicial decisions, the King's judges, the judges appointed by the executive, deciding to abuse power. And that's why originally it was decided that we actually needed constitutional protections. So I just want to echo what Leanne Dalzell said. This is a breach of a Bill of Rights Act provision. There is no vet from the Attorney-General. And while I have some sympathy with what Kennedy Graham says about the need not to get into some sort of degeneration into ad hominem arguments about whether the Attorney-General this time is better qualified than the last, here's the point. It is the Attorney's job to vet these bills. This bill clearly breaches the New Zealand Bill of Rights Act, and it clearly breaches, in turn, the International Covenant on Civil and Political Rights. And the worst thing about that, sir, is that we can make up all the legislation we like, but if it is in breach of those fundamental standards, we know what will happen. We're a party to the optional protocol to the International Covenant. If somebody is treated in the way that is envisaged by this bill and there's unfair treatment, they will go to the Human Rights Committee, they will complain, there'll be a finding that New Zealand is in breach, and we'll be told that we have to fix the law to make sure that it is consistent with our human rights obligations. So this entire exercise, supposedly a money-saving one, is just an enormous waste of Parliament's time. It's an enormous waste of time and money, because we are going to be back here doing this all again if we are foolish enough to legislate in this way. Sir, I just want to say in closing, I hope that the ACT Party won't vote for this abomination. It is, Mr Chairman, it is...
Charles Travell.
It likes to call itself the Liberal Party. Sir Roger is here in the chamber, and I hope he will uphold that party's traditions and uphold what he says is his respect for civil liberties, and join the other parties in the House, I understand the Māori Party, the Green Party, Labour and others, and vote this abomination down.